All right, welcome everyone. It's nice to see you for our weekly webinar as we get ready to head into a longer July 4th holiday. So it's wonderful to see you. Looking forward to covering some topics today that cover how to get a shorter sentence, or on the flip side, decisions that some people make that could lead to a longer sentence. And of course, those same things then transition into serving a potentially longer federal prison sentence. So our team wants to help you prepare for all that's coming. I'll mention sometimes when we go through this list of what can lead to a longer sentence, some people will say, well, that sounds very obvious. And as obvious as it sounds, some people still continue to make those same mistakes. So it might seem obvious, though it doesn't change that. We want to make sure, as obvious as it seems, that you're making really good choices. As a reminder, we continue to post a lot of content. As I see my friend Gary Gibbs just joined, a lot of content on prison professors, including our calculator. Scott, if you would, on the Prison Professors page, homepage, somewhere on the site, there's so much content. We've updated our calculator where you can plug in the length of your sentence, projected RDAP, First Step Act credits, and all that good stuff. And it will send you an email with how much time you could expect to serve. So I encourage you to go through all of that. Now, we're going to share a few stories today, both good and bad, about people going through this system, including some people who in our community who got some great outcomes to that end. And if you're not on yet, that's okay. Clovis, are you with us? Are you able to hear me? If you are, unmute yourself.
Yes, I'm here.
Clovis, yeah. So good to see you. We're going to talk in this podcast about, or this webinar, about things that people do that lead to longer prison terms. You didn't do any of those things. Can you just spend a few minutes helping everyone understand what the potential guidelines were in your case, the outcome you received, and why you think you received that outcome? And thank you so much for joining us today.
Sorry. Hi, everyone. So yeah, I was facing 57 months. That is what the prosecutors suggest for my sentence, and I get 20 months, and I got a self-surrender for 45 days. And I think what helped me, actually, what helped a lot, and I heard this from the judge 3 times, is that he could understand who I am from the letter that I made to him and from my speech. I have like 4 minutes talk with him, and I think in the end that is the thing that helped me a lot to get just 20 months. And actually, again, I feel really happy for get just 20 months. I think it's...
Walk us through something specific you did, because there are people on this webinar right now who are told not to give a release plan to a case manager, who are told not to give a narrative to a probation officer or judge for many reasons, including the lawyer may say, that's what I do, it's not necessary, they already have enough paperwork. So in your instance, do you feel that whether your allocution or narrative in your own words help them see you differently?
Definitely. So Michael helped me how to make my letter, my personal letter. So I spent 4 pages talking about myself, who I am, what I did, where I come from, what I did for work, what I think about the case, how this affects myself, how I see the things I did, and how this can change my life after. So I can put all these thoughts in a letter, and I think this is what helped a lot, because actually my lawyer, it's a public defender, so she think just one like basic letter will be okay, because she say, oh, many judges not even read the letter, and I say, no, I want you to file this specific letter. And so she did, and so it helps a lot. So he talked about the letter like 3 times in the sentence.
So I'm grateful for you sharing that. And I'd love it always to go smoothly, where your case manager takes your release plan or the lawyer's welcoming of your narrative. What you've got to do is advocate. I won't mention the name of our client who's on this webinar, but he sent this email a few days ago that said, as I feared, and I filmed a podcast about this on the White Collar Advice podcast, as I feared, my defense attorney is pushing back and again suggesting I do not submit the narrative letter, having nothing to do with the quality of the letter, just the concept in general. He wrote, You will have a chance to speak to the judge. I think that's more effective than submitting a letter. So if you get feedback, I have no doubt this lawyer has good intentions and wants to help his client and has given him advice he thinks makes the most sense. What you've got to do is not say, well, Justin and Michael and Scott said we do it. No, federal judges suggest that you do it. And if you know a probation officer, the first thing they're ever going to do is look at your pre-sentence report. Does it make sense to have the narrative in there? Yes. Does it make sense to influence this report? Because the first thing your judge will probably do at your sentencing hearing is ask, have you read the probation report? Yes. Do you understand it? Yes. So you want to influence this report as much as you can. And if between your pre-sentence report and your sentencing, things change in your life, you'll simply update the narrative. It's a dynamic and growing document. So if you get that pushback, that doesn't mean you just acquiesce and say, fine, and cower. If you're comfortable with it and you can deal with some uncomfortable behavior, if you can deal with it a little, we encourage you to push. And that's part of what Clovis did. And it's why he was able to obtain such a good outcome. Now, back to the reminder email I sent out this morning, and it's going to get into why people get longer prison terms. Number one, I wrote, doctor expected 18 months. He received 41 months. Why? It's very simple. Well, let me ask you, how long have some of you have been waiting for sentencing? Like I see, I think Steve up there, but how long have some of you been waiting to be sentenced? Rob,
it took me 3.5 years. Just
three and okay, so it's like it's a whole lifetime, and you haven't even been sentenced yet, correct?
I just got sentenced a few weeks ago.
That's right. Okay, that's right. But Rob, how about you in the bottom right? How long?
Everything started February of 2020, and my sentencing is in November of this year.
Right, so that's a lifetime, right? Even if you get probation, a year and a day, 2 years, it's really very little relative to what you've already endured. And judges know and have told us, hey, we know you are not serving time in the penitentiary. I need to know that you're productive. And if I give you the outcome you want, it's because I need to know that you are productive and you're never going to return to this freaking courtroom. So the reason a doctor who had a guideline range of like 18 to 24 months received a sentence of 41 months is clear. Took about 4 years from start to finish. COVID delayed things, cooperation, other witnesses, new U.S. attorney. I think one of his attorneys died. A new lawyer had to come on board. 4 years from start to finish. And the judge said, one, you're a doctor, so I'm going to hold you to a different standard. But two, what have you been doing throughout this whole window to demonstrate to me why you'll never return? The answer is absolutely nothing. So if you're not going to use this window properly and demonstrate why you won't return to a courtroom, you're better off going into custody right now and getting credit for time served, because Steve and Rob and Al, everyone on this webinar, you're not getting credit for time served, even if you got the bracelet on. So make sure you're using this time productively. And this judge filleted this defendant who basically said, have you been sitting on the couch for the last 4 years playing video games? It wasn't a great hearing, and it's part of the reason the guidelines, the judge went above the guidelines in line with what the probation officer recommended. To number two, an angry son called to tell me his dad was only receiving 4 months in the halfway house, but his bunkie was getting 9 months, essentially for the same crime. Both have avoided disciplinary infractions in prison. Can someone, maybe Scott or someone, articulate why the case manager chose to give 9 months to his bunkie and only 4 months to him? Can anyone articulate why such a big chasm?
My guess would be that the person who received 4 months simply came into the case manager's office and asked for the most amount of time of home confinement he could receive, while the other person proved why he was worthy of that leniency.
Anyone else have any insights? Yeah, Scott Seek, yep.
That would be giving them an awful lot of credit. I would say one of the other reasons is that half of the people in the positions of authority do not know their job. They don't know the difference.
So I can argue from speaking with this son, the rage and anger that the father feels about being in prison, doesn't think he should be in prison. And it is naive to not embrace the reality they can read your emails. It's one thing to think they may read the emails just if you're in the drug program, but I can assure you the Bureau of Prisons will randomly search emails, buzzwords, keywords, and they will read them. Might not equate to a disciplinary infraction, but if they deem that you are complaining about programming, not fully engaged in the hustle, whether they write you up for it or not, they will remind you the halfway house is a privilege, not a right. Get out of my office, stop begging. And in asking this son questions about his father, I could sense he isn't having the most productive prison term because he doesn't think that he should be there. And everything feels like a chore and a task. And he complains about absolutely everything. Dozens of cop-outs. Can anyone tell us what a cop-out is? Well, what's a cop-out?
Linda, if you want to unmute yourself.
A cop-out is basically a written complaint that you put in when you're inside. And it's usually against staff, and they aren't real thrilled with them usually. Sometimes it's against other prisoners, but if you're seen as a chronic complainer, in general, it doesn't reflect well.
So I read an article yesterday that Ghislaine Maxwell, Jeffrey Epstein's former confidant, had written something like 400 cop-outs in the federal prison, which would perhaps be a record. Remarkable. Wow. She's clearly looking to get transferred or to get into more trouble or to have something not good happen. This prisoner, I learned from his son, he writes a cop-out about everything, right? Absolutely everything. You write cop-outs when it's severe and serious. Now that can include a bunk change or a job change, medical issues not being treated, things of that nature. I didn't write one while I was there. Michael Santos served 26 years in prison. I can assure you he wasn't writing a ton of cop-outs if he wrote one at all. So we want you to keep these things in mind because it is a subjective process. If they like you and deem that you are easier to work with, they could say, we're going to give you 9 months. If not, they may say, well, we're going to give you 4 months and be grateful for that. And certainly having a release plan would be of value in sharing that information. Number 3, a judge sentenced a client to only 18 months probation when the government asked for federal prison. He left a wonderful review. I'll circle out to this community. Essentially, the judge said to him, I believe that you have changed. I believe that you have reformed. And that was by way of the narrative. The judge said he read 3 times and his allocution statement. So I can't guarantee you'll get the same response from your narrative or allocution statement if our team helps. We believe it positions you to get the best possible outcome through your own words. And then, of course, this narrative will then build into the release plan, and it's just a growing dynamic document. We want you to follow the advice of federal judges rather than a lawyer or someone else who you don't know, who might have good intentions, might give you advice they think is right, but it's not rooted in what we've learned from working with judges. As we continue, I see a hand up. Scott, is that you, or Scott Seek, is that you, or have you already answered? Have I already addressed your question?
No, I want to add one other thing to this disparity with respect to time in the halfway house, irrespective of whether they like you or don't like you, or you're following the rules or you don't follow the rules. They also have very little understanding of another moving calendar that goes along, and that's the First Step Credit Act. Okay, so you might be qualified for X many months of halfway house, and they will grant it to you, not taking into consideration that your PRD, your projected release date, is moving upward or closer by 10 or 15 days, depending on your status, as time goes by. So in the very beginning, they may come back to you and say, oh, we did you a big favor. We got you 10 months of halfway house, only to find out that 10 months isn't 10 months because your PRD date has moved up and it turns into 6. Now, who does that affect? Well, that affects people that really need the time at the halfway house to get situated, get a job, get some money under their belt, get back to life. Well, if you take months away from the halfway house, you may not be able to earn enough money to go and get an apartment or all the things that we consider, that have to be done to get back on your feet. And so my point being is the counselors at the institutions don't take into effect the moving PRD date based on First Step Credit Acts. They go in with one set of paperwork. They ask for X many months based on what they think they can get or what'll get approved. And that becomes it. And they're not going to do it again by chance. So I'll give you an example. A friend of mine who's now home finally on home confinement, he went in under CARES. They didn't process him under CARES. They processed him under halfway house. The explanation, and so she comes back to him and says, for you, I got a great deal. I got you halfway house next June, this was last year, by the way. And I do that because I can get the CARES application. Anyway, make a long story short, there was no CARES. But from June of last year until now, he was accumulating first step credits, 10 days, 15 days, whatever it is. So June really was never going to be June. It was going to be probably 6 months sooner than that based on ETC's First Step Credit Act. So my point being is the counselors really do not know their job. They do not know the nuances of the moving clocks. As a result, you get major disparities. Anyway.
You're right. That's how I want to close. That's the right point. There are major disparities. And the point is, rather than complain and fret, that can only make matters worse. Go about your business, build your release plan, and they could reward you and easily call you in and give you more time in the community. I want you to be aware of that. Let's now transition to this topic of longer federal prison sentence, 20 reasons why. Of course, there are thousands of reasons why, and I can't cover all of them in this webinar. We're going to cover some that we have learned impact why some people get a longer sentence. Last week, I did some role playing with Michael Santos and Scott, some training, and Michael asked me to go back to when I was a defendant and he was interviewing me. And I said, well, I'm concerned about making 3 cents again, my reputation, how am I going to survive? How am I going to make money? What am I going to do? My parents are really upset. And after about 10 minutes, he made the appropriate assessment. When you were a defendant, it was all about you. It was all about how your own life was falling apart and cracking. Not once have you focused on the victims and given consideration to how you'll make them whole besides saying, I'm sorry. So as we wrote, and we'll send this out, number 1, all about me, a lack of empathy, remorse, and understanding towards the government's perspective can adversely affect sentencing, portraying defendants as indifferent to the impacts of their actions. You might not know you're doing it, but I've spoken with many of you and I was you. And typically those calls start with how your own life is falling apart. The government doesn't care. And I don't say that to be rude, but to be brutally honest with you. They don't care. They don't care if your life is imploding or falling apart because they may say to you, you should have thought about that before you broke the law. People on this webinar who cooperate and think they are friends with the FBI agents are later learned to get 4 years in prison. And they'll say, I thought the feds were my friend. No, they're doing their job. Their goal is to advance their career, indict, convict people, get prison terms. That is their job. They are not your friend. They don't like or care about you. I hate to say it, but that's the reality. So if you can put yourself in their shoes, you might be able to convey a slightly different message. Does anyone disagree with me or have any insights to share on this first point? If you've been through sentencing, anyone here?
Absolutely, Justin. I thought FBI agent was on my side to a certain extent. And my case has taken so many turns and all. He was asked to resign early because some of his misappropriations himself. So I don't trust anybody.
What I'm conveying to you is you've got to understand these stakeholders and recognize their goal is to get convictions. And you've got to be honest and authentic. I had a call this morning with a client, a couple of calls. One was very early. He's crazy rich and wealthy. And like his lawyer's like, don't mention that. The privilege and wealth, this is not the era for it. How are we going to manage the fact that you were born into money and you've grown it into more money? What do we do? I can't write a narrative about that. And well, of course you can. You should be honest and authentic. If you're wealthy or you've grown it or you've built it or you've inherited it, you should address that. Then on the flip side, you can then say, that's part of the reason I have no excuse to be in this courtroom. I may serve time in prison or will with people who didn't have the opportunities that I took for granted. And as I go through this process, I'm thinking about them and how I could help, whether it's the Prison Professors Nonprofit or Talent or YMCA. But it's not about me. It's about how I can use this experience to be of value to other people. Don't run from what you've done well in life. Own it and talk about it, but don't lie and claim that it isn't there. Because as I'm going to get into in a few minutes, they're going to go through detailed financials and know every damn penny you have. Please. Number 2, lavish spending, extravagant expenditures, especially when victims seek restitution, signal a lack of remorse, potentially leading to harsher sentences. So knowing they're going to complete a financial review through the probation report, and just because people retain our team doesn't mean they're going to follow our advice. We had a client in Michigan who made money, a lot of money, didn't set enough aside for restitution, though thought it would be a good idea to buy the new Tesla X, invest in a rental property, while thinking, it's fine. Like my guidelines are low and it's fine and not really a big deal. I said, I'm sorry, I identify with victims. So I'm not telling you you can't spend and live, but you've got to understand lavish spending, going above and beyond if you owe money, is going to make you look like a fool in front of a probation officer and sentencing judge. Consider your spending and understand how it relates to what it is you're trying to achieve. Lawyers, mitigation, life is expensive, but they are going to see lavish expenditures. And if you say, I'm sorry, and then spend, they're going to think you're giving them a cliche. You don't really mean it. Consider that as you go through this process. Number 3, how many here lost their?
Justin,
Yes.
if I could really quickly, one of the
Yes,
strategies,
we can't spend
quickly, with
yes,
strategies
quickly.
is, they do it at Syracuse Law School, is that if you have a thing like a year and a half before you get sentenced, set aside your own checking account, and that's did you deposit weekly, and you'll be able to show that this is what you're going to give you, since you've got indicted or charged. Go ahead and set up an account strictly for the victims. It may only be $8,000, but it shows the judge that you tried.
There is no doubt. I know of someone years ago, his name is Gene, great dude in a Medicare case, owed like 1.6 million in restitution. He came up with like $6,800 for restitution, which is a rounding error. It was more symbolic, but relative to what he had, it was a lot, and the judge appreciated that. Keep that in mind. Number 3, well, let me ask a question. How many here lost their career as a result of their conviction? How many? Like, I know I did. Okay. Anyone here have to start over in a career that was beneath their skill set? If so, can you tell me what that was or what it is? Chuck, I see you down there. Chuck, I know you're driving. Unmute yourself. I know you were an MBA licensed psychologist. What have you had to do since your case?
Well, I'm actually having my sentencing date has been pushed back to September 22nd now. It was for July 18th. I am going to be looking at basically becoming a life coach and trying to help some people out who are in the same situation, and somehow manage to put some of my skill sets that I've had over 30 years to work, and hope that is appreciated by the court.
I would tell you, if you can transition to being a life coach from where you are now, I would argue that's not a step down. I'm talking about a real step down, man. Like I went from
I'm also looking at becoming a commercial truck driver.
Got it. And thank you.
Yep.
Anyone else having to really step down to like a minimum wage job? Anyone? I did. So I'm conveying to you what they want. And part of the reason some people don't get the shorter sentence and they get a longer federal prison sentence is they feel like some work is beneath them. They wouldn't do certain things to earn a penny. You need to work to build a new record as a law-abiding citizen. When I came home from prison, I picked up phones for $15 an hour. I, at one point in my career as a broker, was making north of $500,000. A couple of years later, I'm picking up phones for $15. It's part of the journey, though my probation officer appreciated it. If you are going to sit for a probation interview and go in front of a sentencing hearing and cannot articulate what you do for work or that you are looking for work, you, in my opinion, do not have the mitigating factors you need. And it's the reason people get longer federal prison sentences. Like the doctor who got 41 months when he was expecting 18, he sits around all day doing nothing. He could never drive for Uber. He could never pick up phones. He could never deliver food for DoorDash. That's beneath him. He's a physician, not a physician anymore. I'm not a stockbroker anymore. You've got to work and build a new record as a law-abiding citizen, or you may get a longer federal prison sentence. Number 4, reliance on paid advocate. Now, look, we are paid advocates. I'm not naive. I understand that. But some people, as we wrote, an over-reliance on paid professionals and avoiding potential and personal involvement in the defense strategy can indicate a lack of personal responsibility and laziness. Even if you work with our team, you are vested in the interview and the writing and the process. It is not outsourcing. But too many defendants outsource the work to counsel and do absolutely nothing. And as a result, the judge doesn't feel as if the defendant's done the work or demonstrated why they're worthy of leniency. Is there anyone on this webinar who has regrets about outsourcing too much of the work to lawyers? Or can anyone offer any insights on that? Is there anyone who didn't do that work? Anyone? Go ahead, Linda. We can't hear you.
Unmute. There
Yes.
we go. Unmute. All I wanted to say was there was a large part of my journey that I was unaware that you guys existed or people like you existed, and I did not have that rapport with my attorney, and I now regret all the things I could have done writing up a narrative that I didn't do because I was advised not to.
So
And I mean, there are different types of, if you just have your attorney write it up, that I took it for granted. That's what you're supposed to do. The attorney said, hey, just go to the probation meeting. I mean, we lucked out because they didn't treat us too harshly considering everything, but it could have been, so much better. Because I felt that when we got to sentencing, the judge was confused, about the whole thing. It's an IRS case.
Last week, I think I mentioned someone who had retained a retired federal probation officer to create a supplemental probation report from a retired PO who was a PO for like more than 25 years or something. And the report came back that said the defendant should get probation, even though the guidelines were 41 to 51 months. I don't know if this report would influence the judge. What I would argue is this probation officer was paid to produce a report that said he would get probation. So I'm not knocking paid advocates. We are one. What I'm conveying to you is you, through your own efforts, have to do the lion's share of the work and demonstrate where you're going and why you're worthy of leniency. I say it so much because it's relevant. So work with a great team, but if you are not working harder on your case than anyone else, then you're just not ready. And it's the reason some people get longer federal prison sentences. Number 5, and this happened recently, unfortunately, to a client of ours. He retained us just before sentencing, non-compliance with court procedures. Scott Laney, maybe you can touch us on this in a moment without our mentioning our client's name. I wrote non-compliance with court procedures. Ignoring the judge's or court's order can lead to a longer prison term. Scott, I'm referring to someone who just retained our team, who continued to do some work when they weren't supposed to. If you understand the case, can you touch on what he did wrong?
Sure. I mean, there are a lot of conditions imposed upon all of us as we move through this process, and the onus is on us to understand what those conditions are and oblige to them. And in this instance, the defendant didn't do that, thinking that it was just a minor situation and wouldn't really ruffle a lot of feathers. And unfortunately, it came up that there was a violation of those conditions, and there was a severe blowback from it.
So if a judge that's right, this judge told our client, you can no longer work in this industry, but he needed to make money. He has a family to support. He's looking at a very lengthy prison term. And he wanted to pocket some cash. It wasn't illegal what he was doing. The judge didn't want him working in that industry anymore. He did. They found out. And it's part of the reason I believe the sentence was more than 200 months in federal prison. One of the longer sentences anyone in our community has ever received. No joke, very lengthy sentence. Can't undo the past, but if you know you're not supposed to do something and you do it, then you're just asking to get a longer federal. I mean, you're just asking for it. Don't be surprised when it comes. Number 7, continued criminal activity. My co-defendant got indicted on new charges. They ripped up his plea. Any criminal activity or legal infraction during the pre-sentencing phase suggests a disregard for the law. Some people laugh at me when I say this because they're like, dude, do you think I'm dumb? I'm never going to do it. But let me tell you how easily the government can insinuate you committed a crime. You speak with your co-defendant when you're not supposed to. I've seen dozens of those cases over the last 14 years where you text with your co-defendant, how are you, what's new, anything's happening. The government can deem that's an obstruction of the investigation, indict you. And of course, some people continue to commit new crimes. There's no doubt about that. No support network. Number 9, a lack of support network can result in longer sentences due to the perceived potential for reoffending. Did anyone watch the interview Michael Santos did with Chris Maloney, the former chief of federal probation? Anyone recall watching that? It's a very important interview. And one thing that Chris Maloney said was, if you don't have a documented support network, it could suggest that you're going to engage in continued criminal activity, because you need a support network to help keep you on track. It's very clear. Part of the reason, if you don't have that documented support network, there could be more supervision while you're in the pre-sentencing phase. I'm hearing an echo. So to that end, someone who's on the verge of getting sentenced, can you walk us through your process for growing your network and getting character reference letters? What does that look like? Maybe we can all learn from you if someone would engage us. What are you doing to grow your network while waiting to go to prison or get sentenced? Anyone? What do you do? Go ahead. I see your hand up there. Go ahead. What are you doing? Talk to us.
Hey, my friend became a pastor that I'd known for a long time, hadn't seen him in a while. Visited him for a while, had lunch. He wrote a wonderful reference letter. I have sentencing coming up in July. So I was working on some good reference letters. The pastor was one of them. Another friend who's a sales manager at a company wrote a real strong letter saying he'd hire me when I get out, even though I don't have any skills in the HVAC industry, but he has sales positions. And then he knows that there's courses at the facility I'll be going to for electrician or plumbing that can apply to him.
Sure.
So I've just really been networking on and at the same time getting reference letters with the support network.
Thank you for sharing. Many of us lose our network or portions of it, so it just requires being resourceful. I began to grow my network after a good 2.5 years of doing nothing, and it started just by picking up the phone and asking if I could have a cup of coffee. I kind of tested what worked best, actually. For me, people were so taken aback when I called. It's kind of like dating, actually. I learned to not tell someone in person that I just gotten out of prison. I kind of tested that process as well. I would just send an email, to be honest. Hey, it's Justin. It's been a while. I'm in trouble. I made bad choices. Rather than believe what the DOJ said, much of which is true, I'd love you to hear from me what happened and what I'm doing to make amends. And I could use your support. Everyone responded and we would spend time together. Many of them wrote letters and many are close friends till this day who support our work. You need that network both to get a shorter sentence, but if you don't, and you should have them come to your sentencing hearing, some people speak, but if you don't have that support, the judge is going to wonder, why aren't you cultivating it? Because studies suggest you're less likely to offend if you have a support network and stability and employment, which is why you need to be pursuing these things. We do have a free course. Scott, if you could put up a link to characterletters.com, which will walk you through how to cultivate and get character reference letters, including actual letters I wrote when I was a defendant in 2008. And by the way, you know what people love? Something that I did, I would handwrite letters. Everyone texts and emails, nothing like writing a letter, putting it in the mail, people would open it. Nothing wrong with doing that. And of course, send a thank you letter once you get it. And once you get sentenced, edit those letters for your release plan. Gina, I asked you to lower your hand. Please contribute.
I was actually going to let Steve contribute because he's got some good there.
Excuse me. I've spent a ton of time in a 12-step program, and I have a support group of people that have indicated that they want to come to my sentencing, and they're asking if they can talk to the judge, they can write letters to the judge, whatever they can do. I've also gotten a letter from my previous employer who has stated that once this is behind me, they would welcome me back for employment.
So those are the most important letters, the employment letters, by the way. So if you're working, the letters from people with whom you are working are the most vital. I was a real estate agent for 3 years before I went to prison. Those letters were the most impactful in front of Judge Wilson because they were written by clients of mine in the real estate industry. You could read all those letters if you go to characterletters.com. So I love that they're going to come support. Now, keep in mind, Steve, some judges will not allow someone to both write a letter and speak. So you can ask your lawyer to get some clarity. Clients have been disappointed when the lawyer asked the lawyer to get an assessment from the judge. Does your lawyer know the judge? And in some instances, someone gets up to speak and the judge will say, wait a second, I read a letter from you. You already spoke. You sit down. Some people will then not write a letter and speak if they're a better orator. Either way, if they speak, it should be a minute or two or less. It should be on point. Don't give advice like this is a waste of taxpayer dollars. We don't need to warehouse him in prison. All true, probably not the right message. Again, it's not about you. It's about your actions and how they've hurt people. But make sure if people are going to speak on your behalf, they can also write a letter or vice versa. Okay, thank you for contributing. Someone else, forgive me, I saw it up here. I asked you to unmute yourself. Who was that? Brian, if you can lower your hand and unmute yourself, please.
Yeah, I'll just echo what the last person said, which is I built a pretty quick and solid support network because I am an addict and alcoholic. So I was able to jump into those programs. They were great for me. And they didn't have to disclose that they were alcoholics when they were giving me letters for various things.
Letters go a long way. Get them. You can modify them and you don't have to modify them later. You don't have to use all of them. But in my experience, if you have no letters. Now, some people use the phrase cop out, like, oh, I don't want to bother people. I don't want to bother people and ask them for a letter. Total nonsense. It's because you don't own your story. You don't understand your story. You're not in a position to, you need to be cultivating support right now. Just like you need to have several jobs lined up when you come home from prison because the probation officer might not approve it. All these things start by doing that work now. As we continue, an additional reason someone might get a longer federal prison sentence, they resist the opportunity to cooperate, which is what so many people say they won't do. They end up regretting it. You see there's a huge disconnect for those who cooperate and those who don't. Someone recently in our community did not cooperate. It's going to get like 5 years. His co-defendant who served a few weeks in custody is going to get time served. Same crime, same restitution. Same thing. Look at that. 5 years versus like 30 days or time served. Michael got 26 years in prison, went to trial. Had he taken a plea deal, probably doesn't serve 26 years in prison. So if you're in a position to cooperate, understand the pros and cons, and also understand what a Rule 35 is. There could be some risk there. A Rule 35 is post-sentencing cooperation. Typically, you would like to have all of that cooperation done before you go to prison because there's risk of cooperating from prison and people can find out there have been some problems there. Word spreads inside of these camps. So cooperation helps. A number of people will say, I have nothing to give. I have nothing to offer. You have no idea what you have to offer. Just tell the truth. And of course, many people by way of a proffer blow their opportunity. They squander an opportunity, as I did, to get on the right side of the government. Then they beg for a chance to cooperate. And the government says, we gave you an opportunity. You wasted it. You're a two-time loser. You committed the crime and you didn't help us. Have a nice day. Consider cooperation if you can. 13, disrespectful attitude, displaying rudely towards authorities, victims, or the court can lead to a longer sentence. Can anyone give a specific example of what that could include? A disrespectful attitude? I have several examples I can point to from sentencing hearings. Anyone seen that or experienced that or been to a sentencing hearing and seen something that was disrespectful? Anyone? So I saw it. Judge Carter here, Judge Carter, Judge Carner, Judge Selna in Santa Ana. I've been to sentencing hearings where the victims are speaking. And some of these victims can say awful things. And many of you won't agree with what the victims say. Many of you will say it's fabricated, it's made up, they're piling on. And you just sort of have to take it. I get it. They want their pound of flesh. They want to see you suffer. But at several sentencing hearings, I have seen a defendant do good, including clients of ours, do good mitigation work, the narrative, the letters, the allocution. And while the victim is speaking, they shake their head in disagreement. Like, I can't believe this. This isn't true. Just like a little shake of the head. The judge will then interrupt the victim and fillet and embarrass the defendant in the courtroom. All the mitigation work, the cost, everything, flush down the toilet. So your appearance and what you say truly matters. How you approach a probation officer with deference and humility, as hard as it may be. And I can tell, like Scott Seek, who contributed, we know his impression of case managers. It's probably hard for him to show deference and humility, but he knew it was required to try to get home sooner. It's hard, I know, but if the goal is to get a shorter sentence or to get out of federal prison early, it requires you to recognize they are assessing, they are reading your emails, and the probation officer is going to make a recommendation of your appearance. Were you polite? Were you respectful? Clovis opened up our webinar by sharing he got 20 months instead of 57. In a review he left, he mentioned the probation officer thanked him, I think, for his professionalism, for doing so much of the work for him, for taking this seriously. If you don't do that, you're not going to get the shorter sentence you want. If you are not organized with your financials and essentially do their work for them, you're not going to get the outcome that you want. Put yourself in their shoes. Only then are you able to advance your agenda. Any thoughts before I see, let's continue to go here. We have a few more and then I want to go to the financial litigation. No evidence of rehabilitation efforts. Lack of evidence showing efforts towards rehabilitation can lead to lengthier federal prison sentence. Can someone give me an idea of what that could mean? Like if you're a criminal and you've pled guilty and you want to ask the court for leniency, you are rehabilitated. What are some steps that you can put in place to show rehabilitation? Can someone engage Scott or me? What does that mean? Besides, I'll never do it again. I'm sorry, didn't have bad intentions, didn't begin my career. Yeah, give me an idea of rehabilitation, please.
Justin, I had a drug case And even though it wasn't required by the court or by my pretrial release officer, I went to 30 days of inpatient treatment. I attended Narcotics Anonymous meetings. In fact, I was part of starting a new NA chapter, even though none of that was actually required.
Anyone else? What rehabilitation efforts? The court, this isn't me, what federal judges have told us they want to see. If you have yet to be sentenced, or if you want to get out of prison early, if you want to get off probation early, and you have time, clearly you do, you're on this webinar, what are some rehabilitative things you can put in place like today, tomorrow, next week? Besides counseling, which is phenomenal.
Yeah, volunteer work. Just try to find ways to help other people.
To that first point of it's not about you, it's about them. So we have people in our community who support our work at Prison Professors Talent, or they create a course with our team that gets disseminated to hundreds of thousands of people. They're using their skill set as an executive to teach and inspire people they will never meet, people they will never serve time with, but they're demonstrating why they want to help people, why they want to use this experience for good. They're putting themselves in the shoes of people who didn't have that effort. So yes, volunteer work, documenting, and not I go to this, the Judge Wilson, my judge at a sentencing hearing I attended one time, was so funny. He told his co-defendant, oh, you go to the soup kitchen once a month and you must post it on Facebook. You're some hero. It was rude and mean, by the way, it was very insulting. So you've got to document it. It's got to be specific, and you need evidence. And by the way, doing volunteer work leading up to sentencing is great because you can ask the judge to give a shorter sentence with volunteer work, and it's easier to get that volunteer work approved if you've done it leading up to sentencing. So certainly volunteer work, working, I would argue, is the most important rehabilitative effort. So if you committed a crime and you lost your job, or you need to start over, the most important thing we've learned from judges is work and building a new record as a law-abiding citizen. Uber, starting a new business, nobody cares. There's someone in our community who is an educated digital marketer. He's creating his Upwork page right now, and he's beginning to get clients, including me. I will pay him to do some work for us. But why? He wants the reviews on Upwork. He wants the completed contracts. He wants to get 100 contracts before sentencing that says, I did this. This is what I've done since then. I am rehabilitating and doing good work. Substance abuse, working, volunteering, not breaking the law, cooperating, not living lavishly. All of these things are part and parcel to not getting a longer federal prison sentence. I see a bunch of hands up. I'm happy to, I saw some hands, the hands are now down. They're up, they're down. I don't know what week it is. Let's keep going. Of course, misleading on the probation report, financial reforms. Again, everyone says, Justin, I'm never going to do this. I'm not an imbecile. Let me tell you what happens. A few years ago, someone called and said, oh my God, my probation officer is recommending an upward departure. Why? Well, she called my mom. Why'd she call your mom? My wife threw me out. So I'm living with my mom while I wait to get sentenced. And apparently they need to speak with everyone that I'm living with. And on the call, my mom jokingly said, damn it, I guess I'm never going to get that $200,000 back from Travis. Look, she loaned him money. She was never getting it back. He didn't disclose on the financials that his mom years earlier had loaned him money. He would tell you, dude, I forgot. This is my mom 10 years ago. I'm going to disclose it. Yes. Am I not disclosing it? Here's what they say next. What else are you hiding? Any goodwill you've built up, it's in the toilet. So it really requires, and I'm going to go through this in a few minutes with the FLU, the Financial Litigation Unit. It is an audit. It sucks. You need to keep good records, but they don't look at you the way that I or your friends or family view you. I hate to say it. They view you as a criminal. Now, Colette Peters is trying to change that. Colette Peters is not calling us prisoners or inmates. She's calling us neighbors, but I can tell you not everyone in the institute who works there is on favor of calling us their neighbor. They call us criminals and crooks and thieves and inmates. Don't think the culture is going to change overnight. That's being naive. So you've got to be so transparent with your financials. And I don't even think they review all of them or any of them. Sometimes they do, I'm sure. The more you give, the better. Don't forget, it's kind of an inverted process. The more you give, the more it helps you. You cannot lie on your financials or withhold or mislead. I've known people get longer federal prison sentences. They transfer title out of their home once they get indicted, and they don't transfer it back, or they don't disclose it. They're watching. Big Brother is watching. Naturally, the severity of the offense, including the loss amount, it's staggering. Scott Laney and I speak with so many people who are about to sign a plea agreement or have, and they don't understand the sentencing guidelines. They don't understand what wire fraud can mean, the guidelines, why it could be 20 points or 30 points, yet they've signed it. They hope they're going to get probation. We all do. So you really need to understand the severity of the offense, the guidelines, and while all of you want probation, it would be a good idea to do some research and understand some of the 3553 factors in the sentencing is unwarranted sentencing disparities. That's part of the reason. Now, I don't do politics here, but I got all these messages in the last week. Not fair with Donald Trump, not fair with Hunter Biden. Wesley Snipes got 3 years in prison for misdemeanor taxes. What about unwarranted sentencing disparities? Isn't Donald Trump in post-offense conduct threatening the court? Wouldn't most people be taken into custody? Yes. You're not the president or Hunter Biden. Don't know them, don't care. Don't compare yourself to other people. Focus on what you are doing. And I'm conveying to you, you need to know the guidelines and you need to know what's realistic and how to mitigate lower. If not, then you're just going to get a longer sentence if you don't understand what all of this means. Few more here. Victims want justice. Negative perceptions by victims can influence the court's view on the defendant's potential for rehabilitation. Anyone here had a sentencing hearing where the victims have written letters or spoke? Anyone endured that experience? I did. Anyone? Anyone do that? It was brutal for me, victims demanding that I go to prison for 60 months. And the only reason I didn't is because I kind of luckily made choices recognizing it wasn't all about me. I didn't spend lavishly. I gave money back to the victims. I was working. I didn't engage in other criminal activity. I had a good support network. I did volunteer work. I was honest on my probation report forms. I had a good probation interview. So the only reason I was able to combat or mitigate what the victim said about me was because everything else I did was pretty good. Couldn't change what they said. But imagine for a moment, if you are not working, if you are not contributing money, if you are not volunteering and documenting it, if you are dismissive, if you don't understand the guidelines and work openly with your lawyer and you don't mitigate, imagine you don't do that and then the victims speak. Now, some of you might be thinking, well, I don't really have a victim. You have a victim. The government would argue you're a victim. Further, recently, someone didn't presume an insurance company who is the victim would speak. And you know who showed up at the sentencing hearing? A damn suit from the insurance company who our client didn't even know. And, you know, he got up and he said, Todd, let me tell you about the consequences of defrauding our $58 billion company. We want him to go to prison to make an example for all of our executives to know what happens when you cheat. Never imagined in a million years someone would show up and it impacted the judge. Be aware of what victims are going to say. And yes, the impact could be harder if you stole from someone and they're on the street, homeless. That's different perhaps than Medicare or government wasted or tax cases. I understand that. Still, victims want justice. They want pain. They want punishment. And many of them are smart and know that life in a federal prison camp might not be that hard. So your job as a mitigator, according to what Judge Boulware told us in San Diego, he said, I know you're not going to the penitentiary. Let me tell you what good mitigation is. I want to know all of the collateral consequences of your case, of what you're going through, because I don't think prison's the hardest one. Your victims might think the only thing that you're enduring is prison. And I know because I get calls from victims. They're like, you're in a damn country club. It's sickening to me that I'm working and you're running the track for 8 hours laying out watching TV. I'm angry. So what you can do as a defendant is articulate all of the collateral consequences in your mitigation: reputation, financial, embarrassment, shame, loss of freedom, no more guns, going to prison. That's good mitigation. You've got to do that work. That's how you equalize the victims. If not, you are a shooting duck, so to speak. 2 more, didn't prepare for the probation interview. Too many people are told it's a 10-minute interview. No big deal. They're going to ask you a few questions. That doesn't go well. And last but not least, 20, insufficient mitigating circumstances. Lack of significant mitigation circumstances can also contribute. If the government doesn't see mitigation or a reason to go lower, you're going to get a guideline sentence or a higher sentence. Has anyone here gotten a below guideline sentence? Can you tell us why, or said better, or said a little better? Did the judge speak to some of these mitigating circumstances and why he or she went lower? Can anyone share that with us?
Well,
I can just.
Go ahead. Go ahead. Who was that?
That was me.
Go ahead.
I was looking at 17 years is what I scored out to be, and I did cooperate. And I guess I built a little rapport with the new U.S. attorney, and I got 42 months.
So that's a good outcome. That's exactly right. Anyone else want to contribute before I chime in?
Well, I had between 67 months, 1.5 million in healthcare fraud, and but I built a youth football league, cost me 1.5 million, ran it for 12 years at 100 grand a year just to help the kids. And he says, you're not involved with greed. In fact, the money I gave, I was just trying to prove a point on something I gave to the high schools. He says, I can't send you to prison. And they dropped down. When they went to, once a prosecutor drops all the way down to 12 months and recommends 12 months of prison, then the 12 months to 1 day, then the judge will, that's a green light to tell him he can do whatever he wants. And I got pure probation.
That's right. So my friend Andrew Alchek, who died in prison, we had the same judge, Judge Wilson. And Andrew and I used to walk that track, and he would tell me what Judge Wilson said to him, which is essentially, besides the fact that you were a thief, there's nothing endearing about you. The government asked for 41 months. The judge gave him 72 months. A mitigating factor is perhaps you were swept into this. You ran a business successfully for a while, then bad choices happened. It could be a mitigating factor if it was once or twice over a week or 2 weeks versus 2 or 3 years. Mitigation, paying back the money, identifying with victims, the volunteer work. If you have no mitigating factors or anything that shows why you're worthy of leniency, you're just not going to get it. And not only are you not going to get it from your judge, you're not going to get it from your case manager in prison, whose job is to respect the judge's sentence. You want to get home earlier. They don't care. They're going to look at the sentence and the victims and say, I don't even agree. No. So you've got to articulate and identify what your mitigating factors are: cooperation, pleading guilty, paying back money, accepting responsibility, your role in the offense. If you don't do that, then the government's going to have an agenda. They're going to advance it. I can assure you they're working on your case right now. Are you? It's stunning how many people are not. Before I spend the last few minutes going through the financial litigation unit forms for those of you that owe restitution, are there any questions on this topic of some things that you can do or should not do to get a longer federal prison sentence? Anything? Okay. So let me, 1 second, let me pull this up. So we continue to have people who think that once they're done with probation, they're not going to hear from the government. And unfortunately, you're going to continue to hear from the government. So I will send this around to everyone, but this goes to Scott, can you see my screen to the left where it says financial litigation unit? Do you see that?
Yes, I can.
Great. So I received this March 20th of 2018. I received a letter like this every year. And it says, Mr. Paperny, to help update our records and review the amount of your payment, please complete the enclosed statement and return it to this office with your income tax returns, income, copies of your monthly bills, and expenses within 15 days. Now, I got a letter like this every 2 years. Some people get this, throw it in the round file, never hear from them again. Some people throw it in the round file and they get hit with a subpoena 6 months or a year later because they disregarded mail from the U.S. attorney. I always chose to respond to it because I had nothing to hide. I wanted to be honest. Plus, I'm in this business and I knew they were watching me. So when I received this, I had deduced that I was tired of filling these damn things out. So I called them and actually they sued me. It's a long story, but we ended up settling and I paid my restitution in full. But for years, I went through the effort of filling this out. And a number of people say, well, they're asking about my mom and dad and brother and my kids. Should I answer? Should you? What do you think? They want everything because they want the money. So a lot of this is like your probation report, name, information. I can make it a little, if it's too, okay. Name, information. They want your mom's name. They want your dad's name. They want absolutely everything. Then they're going to find out how much you made, recent pay stubs. Get ready to do this every single year. Any benefits? Are you employed, unemployed? How much? Any money coming in the future? Where have you worked the last 5 years? It's very extensive. And let me tell you one thing they look for: liquidity. If they see liquid assets, you know what they want? They want it because they're going to say you owe victims and you said you were sorry and you were going to make amends and you told the judge you wanted leniency because you would never do it again. So these are things you have to understand what's coming. Do some people get shady and take money out of their name and go through that whole rigmarole? I guess so. I didn't really have anything when I came home. I just always wanted to answer it honestly because I didn't want to go back to prison. That was suddenly my highest value. but I'll send this to everyone, but you've got to understand the extent of what they want. And this came 6 years after I was done with federal probation. 6 years. They're following you for 2 decades or until they get all of their money. And you could deduce that if they see some expenses in here, like a boat or expensive cars, things of that nature, they can then ask, why are you spending money on such lavish things when you owe court-ordered restitution? Property transfers. So I share this with you not to scare you, but to help you understand what's coming. And the last thing I'll say about restitution is keep very clear records. If people are loaning you money, document it. Why? That reduces your net worth. We have people here whose family sends them $400 a month in restitution. Document that, because that's eventually money that's a loan that you will put here on the probation forms or for the financial litigation unit, which can then offset lower your net worth. If you make a payment to that person, they could say, why did you make this payment? I borrowed money from them. Here's the evidence of it. You need really clear records. If not, they're going to think you're hiding money or throwing money to somebody else to avoid paying your restitution. That helped me by keeping clean records. That said, any questions about restitution? We've had a lot of people on the webinar today. I'm grateful. Do I see any hands up? Michael, was that your hand up, or Scott? Yeah, go ahead, Scott.
Two things actually go back to a question you had earlier. You asked about things that people should know before they go in that maybe you hadn't touched on. First thing, for those of us that are in the 62 and a half or older age group, okay, bear in mind you won't be able to collect your Social Security. I wish somebody had told me that, because I had actually started early Social Security, which of course I'll pay that penalty for the rest of my life now. Which is a reduction in Social Security benefits because you take it early.
Right.
Didn't know that you couldn't, and the only reason I took it was to assist my wife while I was away. Second thing for everybody, and this is kind of touchy, to those of you going into a camp, you have to understand there are people that have come down from penitentiaries to mediums to regular, they've worked their way down. They have a prisoner mentality, an inmate mentality, unlike many of us that go in that are very white collar, may or may not even think that what we did was wrong, but obviously we got convicted. A cooperative arrangement with a USAA prosecutor shows up as a 5K, I believe is what they call it. And a 5K is fine. You're thinking, okay, well, I've cooperated. They're going to give me a reduced, a recommendation for a reduced sentence. And so it goes, you get sentenced and it gets reduced to whatever. I want everybody to understand, though, that when you're inside, everything about you is of public record to anybody who wants to see it. Other inmates, they have ways of checking and looking into you. So in my case, didn't really affect me, but I have a 5K. I cooperated to whatever extent you want to call that. And I was kicked out of the TV room because in their definition, a 5K is a, what's the word? I can't even,
You're a snitch.
A snitch. That's the word I'm thinking. Exactly. Now you can call it what you want, but okay, out I went. No TV room because I had cooperated and a 5K was filed on my behalf for a sentence reduction. So I want people to understand that your personal life is an open book inside a prison.
Well, even harder now, because when I was in prison, there weren't the iPhone issues, but now so many guys they have an iPhone, and as soon as you get there, they'll Google you. And the government oftentimes in their press releases will state defendant is cooperating in an ongoing probe. So it's very easy for them to find out, which a lot of people in prison cooperated and many people regret not cooperating. Regardless, these are things you need to be aware of. And there is risk for the Rule 35. We've had many clients get Rule 35s, but it's harder it's just riskier if people know that that's coming in prison. I see someone that just says iPad. I don't think that's your name, iPad, but please lower yourself. And I've just asked you to unmute yourself. Hi, Pat, welcome.
This is Ann Gilmore in Alabama. I just wonder, I have two probation officers, kind of. I have a new lady, newly employed, who is writing my report. But my probation officer is a gentleman, and he is who I talk to or report to. Does anybody else had that situation?
That you have two probation officers?
Yes,
It's a federal case?
yes.
Don't know why. It's sometimes, I mean, I don't really have any specific reason why, just be compliant with both. Sometimes we'll have people who live they're in one district, they relocate to another district, and both probation officers can oversee them for a while, but I don't have any good reason why you would have two federal probation officers.
Is this talking about having your local one that's overseeing your day-to-day and an additional one?
Have you already been sentenced?
I won't be, mine too has been put off to.
So forgive me. So what you have is a pretrial services officer and then you have a probation officer who's writing the report. They're two different people.
And I agree with that.
Right.
I think that the lady, she said, I'm not your probation officer. I'm just writing your report.
Okay, well, it's nuanced, I suppose. If she's writing the report, she's the probation officer, or she has some influence on what's going to happen at your sentencing. So let's not parse it out. Let's just say you want to influence her and do everything we conveyed in this webinar, working, volunteering, documenting it, advocating, regardless of what her role is. She plays a role in what happens to you at sentencing. So just acquiesce and do the work.
Does, just one final, I know you're trying to get off.
No, I'm not trying to get off. I'm good.
The male probation officer, and I know that was done specifically based on a comment by who I thought was the pretrial services. Will he have as much or any thing to do with my sentencing?
In my experience, the pretrial services officer can harm you than help you. If you're not compliant on pretrial, they can go to the judge and recommend that you be remanded because you're not compliant. But I haven't heard of a pretrial services officer being at a sentencing hearing and the judge valuing their opinion. They could, the judge can call them and say, has this person been compliant the last 2 or 3 years? I'm sure that happens. In my experience, it's usually the federal probation officer who wrote the probation report who's going to have the largest influence, and they're usually at the sentencing hearing. So keep that in mind. They all work together. They all have access to your documents and records, and they're going to be heavily involved in what happens to you.
Finally, I would like to thank the team that has been helping me, because it has made a tremendous difference.
Appreciate you saying that. Thankful. We're grateful to help and to have everyone here. Thank you very much for saying that. Keep us
Justin, if I could put a positive spin on restitution, that in most cases, because you were in business, that goes for your charge as well. Restitution, not asset, not forfeiture, but restitution can be taken off as a business expense.
That's a funny point you mentioned that. And I had a conversation recently with a lawyer about that and an accountant. Some lawyers and accountants say yes, some say no. I never deducted it because I don't ever want to get in the crosshairs again. But that is a legal and accounting question. But I have heard that before. In the middle here, I just asked you to unmute yourself, please. It's I speak in movie quotes. How are you? Thank you. What's your question?
Basically, I've been watching you guys for a while. My house was raided by the FBI and the California Department of Insurance back in September. And March 31st, the grand jury indicted me for the state. I still have not, my attorney's been in contact with the feds. They have not chosen to do anything. Actually, on March 7th, I had a proffer, and they had a verbal between my attorney and the AUSA, and then he got taken off of the case, and the new lady does not want to speak to him. So my question to you guys, I hear everything for the feds. I know that it's 50 states and you guys can't do everything for all states, but are you familiar with this? I'm trying to figure out how to navigate for both sides somewhat simultaneously. And since the state is moving faster than the feds, I don't know that that's going to be able to happen. And so, and I'm hearing what people talking about their sentencing and 6 months, 3.5 years. I haven't even been charged federally yet. It's a PPP case. and I've been listening and watching and reading everything you said. I'm trying to reach out to people who have been declined for PPP, which I assume I'll get restitution, and then hopefully that will be a mitigating factor to the people who did not get it, to potentially try to make a separate restitution to try to pay them as well. I'm just trying to figure out how I can move forward and get this behind me as quick as possible.
Well, unfortunately, it takes a while because the government has so many cases. And if they know you're not at risk to the community right now, they could let it sit for months and months and months before they ever get back to you, especially if you're working, you have a lawyer and they know you're not breaking the law. In a PPP case recently, it was 18 months before someone heard from them again. While you wait, I would do what any defendant should do, which is make sure you've written out that narrative so your lawyer knows every detail of the case, every nuance of the case. Most PPP cases I've seen, or all of them, eventually go federal, which is probably better for you due to the sentencing guidelines, the First Step Act and early release component, plus the feds have more money compared to the states. So it tends to be just a matter of time before they come in, which is probably beneficial for you because it would be time in a camp. And just understand it takes a while. And in the interim, you've got to do everything I articulated earlier in this webinar to ensure you're positioned if and when the feds come or they refer it over. If the feds do come, you want to make sure any state case is resolved before you go to prison, because if not, you go to a low security prison and you would be ineligible, for example, for some programming like the drug program. And I believe you'd be ineligible for the halfway house. So you want to make sure all state cases are resolved if it becomes federal.
So basically, if I'm understanding you correctly, my insurance case in the state of California, don't try to run those concurrent. Finalize my insurance case in potentially up to 18 months that I have with the state until the feds decide to do what they're doing.
Right.
So then I completely fit.
Yeah, what I'm saying is we're not lawyers and we're not going to give you that legal.
No, I got it.
Yeah. What I'm conveying to you is if there's a case and you know if you go to trial, you won't win. And I know you're suffering in many ways while you wait to get clarity, right? Stress is on you 24 hours a day. If you know you wouldn't prevail at trial and you're under indictment, what steps can you put in place today, regardless of the case, to get the shortest sentence possible? Because that mitigation work you do for one case will translate over to another case, right? So they're all connected. So just use this time productively. And clearly you are by attending our webinars and growing your network and working. But I'd really make sure your lawyer understands every detail. It's sad how many people sign a plea agreement and they're like, this isn't what happened. And they quiz the lawyer and the lawyer can't really articulate what happened. The lawyer didn't fully understand it. It's not always the lawyer's fault. A lot of times defendants don't know what they did. They can't articulate it. So that's a really good exercise, healthy, cathartic exercise for you, whether we do it or you do it on your own. Create that compelling narrative with everything you did and get it to your lawyer. Only then can they mitigate.
That works. I appreciate it.
You're welcome. You're very welcome. Good to see you. Let's see. I see iPhone, lower hand. I might have already done that. Any questions? Someone asked if I could circulate around the documents from the financial litigation unit. Yes, I will send that out. Someone asked about a Rule 35. That's post-cooperate. That's cooperation post-sentencing. Most people typically want to have all the cooperation done before sentencing, but that doesn't always happen. Michael White, are you there?
Yes, sir.
Did you have a question?
No, I didn't. I just wanted to thank you, Justin. This is my last time I'll be on. I want to tell everybody they really need to listen to you guys. I've done the blog. I've written my release plan. I've done everything. I feel prepared, and I really, really appreciate what you and Mike have done.
Well, not just Mike and me, our whole team, from Scott to Carol, we're grateful.
Absolutely.
I'm going to actually reach out to you this afternoon and ask you to leave a review of our work. Okay. So I'm going to send you that. I'm going to send you that. And if anyone would ever like to do that, we'd be grateful, whether you hired us or not. We're just striving to provide value and help. Okay. So Mike, I'll send that to you. And also there's one other thing we have to follow up with before you go in, but Mike's been on every webinar, which is awesome. So thank you so much, Mike. Let's see, any other questions before we wrap up our weekly webinar? No? Okay.
Please, I have a question.
Say that one more time.
I actually have a question, please.
Yes, please talk to me.
The question is, I want to know, I'm actually not a citizen yet, so I want to know if when I'm being, if I don't spend up to like 12 months in prison, will I be released to immigration, or I can be released to go home?
I didn't hear the question. I think I heard that this is an immigration case and you're wondering after you serve time in custody, will you be held like an ICE or will you be able to go home?
Yes.
So a lot of that,
I'm being sentenced to a year and a day.
a lot of that comes down to your mitigation. Clovis, who spoke earlier, mentioned that in the review, his judge, it's an immigration case, his judge advocated that he remain in this country. So besides getting 20 months when they wanted 57, he's positioned himself to stay in this country. So you want the support of the judge if you can, the US attorney, while you're a law-abiding citizen. That's part of the mitigation. But there have been people who serve their sentence and they go, for example, to SeaTac in Seattle and sit there in ICE holding. Others come home. Some even have gone to the halfway house. So a lot of this comes down to your mitigation and planning and what you're doing to prepare for all scenarios. So it's possible you go home. It's possible you go to ICE detention. I don't know anything about the case other than to tell you they're all possibilities. And to the extent that you can influence the outcome you want, I would get started now.
Thank you.
You're welcome. Okay. My plea deal said I needed to complete 2/3 of my probational period. Is it possible to end it sooner? Sure. You can petition the judge and request to get off probation earlier if you like. Kind of need that release plan, a good record and all that good stuff, but certainly it's possible to get off probation earlier. I haven't seen a whole lot of those in plea agreements, 2/3 of my probational period. That's interesting. But it's possible. The worst the judge can say is no. Okay. Okay, guys, thank you so much for contributing. I think I've answered. Do you have one more question up here on the top left? The movie quotes, are we good?
Yes, one more question.
Yes.
Have you guys seen a lot of state cases that will defer and just allow to be for the Fed to serve concurrently, or is that not anything in your?
I would say I would say most. We had a case recently where you had a federal case and a case in Alabama, and the state did want a concurrent sentence. It could have been concurrent or consecutive, and the math turned out that it was actually better that he took the consecutive. Anyway, however the math worked out, some states may want to see some prison time. It kind of depends, but a lot of times, like the state will be satisfied if they get the Fed time. Sometimes they really want to see some state time as well. And there are things to consider, like even if you get 41 months with the drug program and halfway house and good time, you may only serve 12 months. Well, what if they want 3 years on the state? Does that cover it? These are things you have to kind of compute and plan and consider when it comes to sentencing. Generally, you want to do Fed time, not come out and go serve time on the state as well. These are all things you work with, whether they're your lawyer, we can help and resolve it. But I've seen the state time. I've seen the state want some state time too after the Feds. Okay.
Hey, Justin.
Hello,
Yes.
Justin.
Hi.
Hi there. Can you hear me?
Yes.
Great. Quick question for you. We were told from our attorney that there has been a contact from the local city detective.
Yep.
Was trying to reach out to the attorney about the case, and we spoke about this yesterday. Is this going to be developed as a state or the federal case, or how do we even know whether this is something that will stay in the city level or the state level or the federal level, or how do we go about just getting information?
So sometimes if it's a federal crime, if some crimes are federal, wire fraud, mail fraud, moving money, money laundering. So some crimes classify as federal crimes. So the feds are going to pick it up. So it could be referred out. Some cases, we got a call from someone who was a theft case here in Los Angeles. The local district attorney is managing it. It was not a federal crime. So they'll kind of assess the seriousness of it. Is it worthy of, they could refer to the feds and the feds say, we're too busy. The feds get referrals all the time. They say, you keep it, you do something with it. This isn't a priority for us right now. So you may never know why it stays in one district or goes federal. But if they deduce a federal crime has been committed, like mail fraud, wire fraud, securities fraud, that is a federal crime, which is when the feds come in. And we work with some state cases where it's state for a while, and then they see some money was laundered through a bank, which of course is a federal crime because you're crossing state lines. So they'll kind of make an assessment, but sometimes the U.S. attorney just doesn't want it. And I've seen a lot of that. I mean, years ago, we had a client who was cooperating and he gave incredible information, criminal information. The U.S. attorney's like, yeah, it's a crime, too busy right now, not interested. They didn't pursue it. These things happen. So the answer is, I don't know. All you can do is just mitigate, work well with your lawyer, speak openly, hold nothing back. Too many defendants at this stage tend to sugarcoat it, kind of put a message out there that they want people to believe that the more vulnerable and honest, the more bad things you share, that's the only way that people you hire can really help you. It took me a long time to get that. And then I'm telling you, the more bad stuff I shared, the more it helped me because it's refreshing. They're not used to hearing it. Even Judge Boo in a YouTube video with Michael Santos said, you know, if a defendant tells me they broke a federal law, I'm more inclined to believe them if they say, but I didn't do this law. They've just admitted a federal crime. But if it's a blanket denial, I didn't do it, and I know there's evidence they did, it's not going to work well for them. Keep that in mind as you mitigate. If you've done some of these things, own it. Only then are you in a position to say, but I didn't do that. They're only going to believe you if you have credibility. And you can only do that if your lawyer knows and they tend to get all of it anyway. That's kind of the irony, right? If you ever proffer or meet with the government, like that 95% of what they ask, you know, that they know the answer to. You just want to see if you confirm, connect the dots for them, you clarify, are you honest, but they already know. I assure you, they already know. They know, because they're not coming to you unless they've done their work. I mentioned when I spoke at the FBI Academy, the agent, my friend Paul Birch, he arrested me, then invited me. He's like, when we show up at your home, it's the bottom of the 8th inning. But we all think it's just beginning. Oh, they just showed up. No, it's the bottom of the 8th. They know everything. These are things I'd like you to keep in mind. They know everything. So confirm, and only then can you correct. That can be a video, confirm and correct. Yeah. With journaling and memorializing how you publish from inside, I'm having trouble finding tips to successfully accomplish this. We should cover that in a separate video, journaling from prison, something that Michael did for a very long time, and I and others have kind of modeled and learned from that. So we'll cover that, Jonathan, in a separate course, a separate video on how to do that. We've covered it, but we'll cover it more extensively. Okay. Anything else that we haven't addressed? Okay. All right, good. Grateful to all of you. I will get this replay up, get these forms out to you along with the calculator. Someone said they'd like us to spend more time on the calculator. We will. And we're also going to be adding it to the White Collar Advice homepage. Alvin, so good to see you, my man down in San Diego. Good to see you there. Thank you again, all of you, for joining. We're really grateful to help you, and we look forward to seeing you again very soon. Okay, happy 4th. Be safe out there. Okay, thank you again. Bye-bye.
Thanks, everybody.
Bye-bye.
Bye.
Take care.
Bye-bye.
That's the end.